If you smoke cannabis, does that mean that you should lose your right to bear arms under the Second Amendment? That's the question the U.S. Supreme Court is going to be addressing in the coming weeks. And the answer might change the lives of millions of Americans, including those in the hemp and cannabis industries. Hey, I'm Morgan Davis. I'm a health and wellness attorney based in Raleigh, North Carolina. Let's talk about how to keep your business protected and thriving. When the government restricts someone's right to bear arms under the Second Amendment of the Constitution, the government applies a strict standard of analysis as to whether or not that law falls within the historical tradition of firearm regulation. That's the standard. In the past, courts have upheld restrictions on people who presented a risk of some kind. Intoxication, mental illness, violence. Those were deemed risks too high in comparison to someone's Second Amendment right to bear arms. But in the late 1960s, Congress passed a law making it legal for anyone who is a drug user to be prohibited from possessing a firearm, specifically if they were an unlawful user of a controlled substance. And that's where it gets messy. What does unlawful user mean? And these days, what does a controlled substance mean if you are, say, in a state where cannabis is legal, even though it's federally illegal? Or if you operate in the hemp industry, which is legal, but your state law enforcement has a different opinion that your business is not legal, then is it a controlled substance? Can you still have a constitutional right to bear arms? The law never defines what a drug user is. There's no understanding of, is it frequency? Is it type of controlled substance? Is it method of use? So without that definition, the courts are left to interpret it for themselves, which has led to a variety of findings. More importantly for this conversation, it includes someone who may have smoked cannabis, legal or illegal, months ago, who tests positive on a drug test for THC. They can have their right to bear arms revoked, even if in that moment they're totally sober. Now here's where the issue stops being abstract. I, as an attorney, have represented clients in the hemp and cannabis industry who were business owners, whose actions were thought to be illegal by local law enforcement and were charged with crimes. And as a result of that, their right to bear arms within that state, carry a concealed weapons permit, possessing the firearm itself, was revoked long before their case was decided and dismissed, or however it was resolved. None of these people were doing anything illegal in the sense of drug users with consumption or addicts who were actively consuming. They were legal business owners who were in a business that law enforcement in some states still doesn't like and still doesn't understand that the 2018 Farm Bill made it legal. So what does that mean? That under the current scheme, you can have your constitutional right to bear arms revoked for legal behavior, for legal business. So let's talk about what happened in the U.S. Supreme Court case. In U.S. v. Hamani, Mr. Hamani was found in his home with a firearm. He was not intoxicated at the time, but at some point made an admission to having consumed marijuana at some point. That in and of itself triggered a drug charge in federal court. Fast forward, the case goes to trial. The trial court finds that the law as applied to Mr. Hamani is unconstitutional because drug user as applied in this case is overly broad and too vague, that it could have applied to millions of Americans who may have at any point in their life consumed a controlled substance and was not closely enough tied to the action at hand. Federal government appeals. The Fifth Circuit finds in the same as the trial court that it was unconstitutionally vague and overly broad as applied to him. So now the Supreme Court will take up the case. If the Supreme Court sides with the state court, it could result in the revocation of a law that prevents millions of Americans from bearing arms because they may be in a hemp or cannabis industry, because they may have previously used a controlled substance, many reasons. It could make a difference for lots of people who have had a question mark for a long time of, can I constitutionally exercise my right to bear arms while also being a cannabis user? Even if the federal government doesn't agree with me, but I live in a state where it's legal, can I have a gun? This is especially near and dear to former military who so desperately need access to cannabis products, but often fear that using them or being known as using them will result in the revocation of their right to bear a gun or to own firearms. For hemp and cannabis entrepreneurs, this could be the difference between a business owner who has a gun in their shop for their own protection and not being able to do that, which is a common, most convenience store owners, most vape shop owners, most restaurant owners, a lot of them, whether or not they're in the hemp and cannabis industry, will have a firearm in their establishment for their own protection or the protection of their home or their family. But if you're in the hemp and cannabis industry, there's a big question right now, especially under this law of, does that mean you're violating federal law? When the opinion comes down, I'll break it down right here. So make sure you subscribe and stay informed, and I'll update you soon. Because if your rights to bear arms, your constitutional right, can be revoked for legal behavior, every American should be aware of that. Stay tuned. We'll update you soon.